Hello and welcome to the Sandip Roy Show on Express Audio.
The Sandip Roy Show.
Courts are a huge part of the checks and balances holding together Indian democracy. Every time there's a new Chief Justice, we see reams of coverage of what it will mean for the relationship of the court with the executive. When a major verdict comes out, we see a lot of media coverage about what that means for India as a country. And over the last 10 years, we've seen a lot of landmark cases: privacy, Aadhar, Sabarimala, Hijab, defection law, electoral symbols, 377, UAPA, the tussle between the central and Delhi government, to name just a few. While each of these cases is important, does it tell a different story when you look at them all together? With the benefit of hindsight, what do the last 10 years of Indian courts, especially the Supreme Court, tell us about the direction in which the country is headed? And sometimes, more important than the cases the court took up, what are the cases the court declined to take up? Because sometimes no action is even more important than action. Where are we in the push and pull between the executive and the judiciary now that a government with clear majority is in power rather than a coalition one? Gautam Bhatia is a lawyer and constitutional scholar who has been tracking this and blogging about it for a while now on the Indian Constitutional Law and Philosophy blog. His new book is Unsealed Covers, a decade of the Constitution, the courts, and the state. And he gives us a bird's eye view of an eventful decade in Indian courts. Gautam Bhatia, welcome to the show. Well, welcome back to the show.
Yeah, thanks. It's been a while.
One of the things many of us don't realize is what you say in the book is that the Supreme Court was primarily expected to function as a constitutional court. And now it seems like, we go to it for everything from whatever, Rahul Gandhi's defamation to book bans to the national anthem, whether we should play it in a movie theater. When and how did that start changing?
Yeah, so if you read the Constituent Assembly debates, they contemplated three roles for the Supreme Court. One was to, of course, decide constitutional cases involving fundamental rights, cases of that kind. The second was to resolve disputes between the federal units, so disputes between states or disputes between the states and the center. And the third was to settle differences of opinion between the high courts, to lay down the law, for the whole country. So it wasn't just a constitutional court, but a little more than that, but also not, a court for everything. And that role, you see, played to a reasonable degree in the first 20 years or so of the court's existence. Somewhere in the mid-1970s or late 1970s, there is an explosion of cases where what was meant to be the exceptional jurisdiction of the court, so it's called special leave jurisdiction, where you think that the High Court has made a terrible error, and so you have special leave to appeal. That became the normal jurisdiction of the court. And now actually in the working week, Monday to Friday, 2 out of 5 days are set aside just for this special leave petition. So 40% of the working week is the court effectively handling these special leave petitions. So it's been something that is exploded in the late 1970s and has just become worse and worse since then.
And now you write that while obviously, everybody thinks of the Supreme Court as very powerful, that in the current scheme of things, there is one Supreme Court, and that is the Supreme Court of the Chief Justice of India. How much power does the Chief Justice have? Because this is not like the American court where John Roberts can be a Chief Justice for decades and decades.
Yeah, the Chief Justice has immense power in the sense that the court has 34 judges, and the normal bench strength is benches of 2. And then when you have slightly more important cases, final hearings, you sometimes sit in 3. And when you have constitutional cases, you sit in benches of 5. And the assignment of cases and assignment to benches is at the sole discretion of the Chief Justice. And there is no set of rules or enforceable guidelines that can curtail that discretion. So in effect, the Chief Justice picks the benches. Now, judicial ideology is a fact. And I think the Indian courts are a little strange or a bit of outliers in not recognizing that. So most other courts recognize that the American Supreme Court, is a clear recognition that there is something called judicial ideology. You have conservative judges. You have judges who are liberal in terms of how they interpret the Constitution. You have judges who are skeptical of state power, judges who are deferential to state power. There's nothing untoward about that. Now, when in a court of 34, you have the Chief Justice getting this ability to pick benches, and of course the Chief Justice knows their colleagues very well. So they are fully aware of who is deferential, who is skeptical of state power, who is a judicial conservative and who is not. So it's obviously not determinative in that judges can surprise you, judges can be persuaded, judges can change their minds. But there is a non-trivial influence on the outcome if you get to pick the bench. So that's the issue.
Has it always been this way that the Chief Justice just gets to be the master of the roster? I mean, why did we never have a system that was more like sort of random drawing of the lots or something that would be less dependent on sort of one Chief Justice and whatever he or she chooses?
It's a function of the expansion of the court. So when the court began, it began with 6 judges who sat what you call en banc, which is that they all sit together. If you look at the US Supreme Court, 9 judges sit together. South African Constitutional Court, I think 15 judges and they sit as 11 or something of that kind. So in most constitutional courts, there is a correspondence between the strength of the court and the strength of a panel, which makes the powers of the Chief Justice as master of the roster essentially administrative. When you have 34 judges and panels of 2, then that's a very different situation. So that's been the problem. We have expanded the court, and in doing so, we have converted the master of roster powers into something much more substantial, but we haven't looked at how the court's expansion then affects what is meant to be purely administrative in nature. As I said, the problem is, increased by the fact that there is just a non-acknowledgement of the fact that judicial ideology is a thing. So recently Chief Justice says that it's not a polyvocal court, it's it's one Supreme Court, and it's just a function of judges coming from different parts of the country. But there's a lot more than that. Every judge has a certain way they approach the Constitution, they approach interpretation, they approach laws, and that has an impact on how you decide cases. So there is no one right answer to many cases, and especially stuff like granting of bail in a UAPA case, for example. A lot depends on, as a judge, what you think of the criminal justice system, what you think of punishment, what you think of the state's role, what you think of how to balance liberty and, crime control.
I want to get into UAPA, but first let me ask you, Gautam, this book looks at a decade of the legal system here. And over that decade, we've had several Chief Justices. If you map it from Chief Justice to Chief Justice, how has the relationship of the court to the executive, where there's always push and pull, changed over this decade?
So I think one point I make is, among the Chief Justices that I've analyzed, there's been broadly a continuity in terms of deference to the executive. And what I say is that, over time, the Supreme Court is really metamorphosing into an executive court in the degree and the extent of deference it accords to the executive. So that's been continuity over Chief Justice. Every Chief Justice is different. Some negotiate for more space, or able to negotiate. I don't mean negotiated in a bad sense. Are able to carve out more space, some do less of it. So there's been that push and pull, but overall there is a culture or a tradition of deference that has been entrenched in the court over the last decade or so. And that's been the case throughout. Whenever in our history we've had a strong majoritarian government, whether Nehru or Indira Gandhi or the present government, Modi, there has been deference from the court. That's the way it is both in India and across the world.
But under which Chief Justice recently do you think the drift was most pronounced?
No, I think under all of them there's been that drift. I don't want to name specific Chief Justices. They are analysed in the book, their tenures. I think it's an institutional issue. It's not a personal issue.
So would you say that when there is a strong executive, the court, there is like a push for all institutions, including the court, to be less of a watchdog and more of a partner?
No, I wouldn't put it that way. What I would say is that every constitutional institution, and this is in the nature of things, is always trying to, subtly or not so subtly increase its power or its terrain of operation. And in a healthy functioning system, there's a balance of power. And so you have a little bit of struggle always on lines or, on the spectrum. But there is an acceptance of what the core domains are. What happens is when you have a strong executive or an assertive one, they do what is called constitutional hardball. So, they try and push the boundaries more. They see what they can get away with. They see there's a response from the other institutions. And if there is, sometimes they back off. If there isn't, they push more.
So what's an example of that?
For instance, when the Supreme Court gave its election commissioner's judgment recently and said that there has to be this 3-member panel, the Chief Justice, the Prime Minister and the LOP. And the reason for it being that the executive should not dominate the selection process. But it is open to Parliament to pass a law that entrenches the selection process, keeping in mind this principle. The bill that then comes is one that effectively undermines the judgment while pretending compliance. And then you have the Delhi judgment from May. Within a week, ordinance comes out that undermines its basis. So that is the executive trying to see how far it can push the court, if it can redraw those lines a bit. And of course, in both cases, the court's response is awaited.
One of the things that in this book will particularly bother you about what's happened over the last decade, more than particular judgments and their pros and cons, are sealed covers and judicial evasion.
Yeah.
So let's talk about each of those in turn. So what are sealed covers and why are they so worrisome?
Yeah, so sealed covers is recent practice, or well, not so recent, but recent explosion of a practice where in a case the Supreme Court asks, or any other court, asks one of the parties to hand over certain information relevant for deciding the case in a sealed cover. Sometimes the other side gets to see it, public does not, and sometimes even the other side does not get to see it. Right? Historically, you've had the use of sealed cover in certain contexts. So for example, if in a corporate case you have price-sensitive information that you need to, decide the case, okay, fine. It can go in a sealed cover, so only the bench sees it. Or you have, say, a disputed election. So what the court says is, look, let the election results be given to us in a sealed cover. You don't act upon the results until we decide the case. So you have those situations where the logic of the case requires information to be provided, in a certain kind of confidential manner to the court to decide the case in a certain way. What we have seen now is this habit of the state, where when the state is challenged in a constitutional case, the state says, yes, we'll give you information, but in a sealed cover, and often even the other side can't see it. So I'll give you an example. Under the UAPA, there is a provision to ban, groups, organizations, and so on. So there was a Delhi High Court case I remember following from a few years ago, where there was an organization that was banned, and the organization challenged the ban in the High Court. And in the High Court, the state basically gave evidence that it used to ban the organization to the court in a sealed cover. And even the other side could not see it. So basically, I am the lawyer for the accused. I am defending them. And I am saying the ban is unconstitutional. And I am not given a chance to see the basis of the ban. So on what grounds can I challenge the ban? That is a complete farce. It is, what the Star Chamber in the UK would do in the medieval period. You convict someone and don't tell them on what basis you're convicting them. That's one example. The other example is in the internet shutdown cases, for instance, where again the state says, oh, we took the decision on certain information, we can't reveal that to you, so we'll give it to you in a sealed cover. So the court, if it's going to uphold state action or for that matter strike it down, which it rarely does, but assuming that it still does that, it has to demonstrate in the judgment that, okay, look, this is the basis and the materials upon which I have upheld this state action under a constitutional challenge. And that is the basis on which then the public and academics and journalists and all can examine and critique the court's judgment. That is the basis on which a healthy legal culture rests. When judgments are given on the basis of sealed cover evidence, then nobody knows what your reasoning was, what the material was, why you judged this way and why not.
Even if the government says we're going to give you this evidence in sealed cover, can the court say, no, you can't give it, you have to give it in unsealed covers, or do they ever say that?
Well, there's a recent judgment in the Media One ban case where the Supreme Court present Chief Justice laid down a set of rules and principles governing when it is possible to submit in a sealed cover and when not. But that we have to see whether it will be followed properly or not.
What about judicial evasion?
Judicial evasion refers to a situation where the court, by not hearing a case, effectively decides in favor of the executive or the state because status quo benefits the state. So take, for example, Aadhar. So the first Aadhar challenges were filed in 2012, 2013. The case was finally heard in 2018. That was 6 years. In those 6 years, Aadhar effectively became a fait accompli. So, the court's final hearing when it happened and whatever judgment it gave was in the context of it already having become this part of our daily lives. Internet shutdowns in Kashmir, when internet was shut down on 5th of August, the case was finally heard and decided sometime in January. And then it was unclear and vague and it went back and second round and so on. All that time, the internet remained shut. Electoral bonds, right? 2017, the case was filed. Now we are in 2023. And you have had multiple state elections and one union election where you have used electoral bonds. So the point is that status quo benefits the executive of the state. It is challenged, and the court, by simply delaying hearing the challenge and deciding it, allows for the practice to go on, and thereby it benefits the state because they benefit from the status quo.
Now, all these cases that you mention about things that have been pending for so many years, whether it's judicial bonds or the Aadhar case, Kashmir, and so on and so forth, it makes me also think that in that sense, even though most of us welcomed the 377 judgment when it came, actually did it sort of happen far more quickly, the speed at which that was addressed as opposed to, say, Kashmir or electoral bonds or certain life and death issues? That's surprising.
So I think two things here. One is that yes, it was atypical in the sense that the speed with which it was referred to a 5-judge bench and then decided was atypically quick. That there's no getting away from that. At the same time, I don't think I would blame the court for that because, you've criminalized the whole section of our people for many, many years. And, in that sense, they've been waiting for 160 years for justice in that way. I think the important thing is that one should not be at the cost of the other. And it need not be. Right? Because again, the Supreme Court has 34 judges. You can easily set up 3 5-judge benches at any given time. And it has happened in the recent past when Justice Lalit was Chief Justice, who hear cases in parallel, in tandem. I think again the problem is that historically it has been Chief Justices who have wanted to retain that control over constitutional cases. And fair enough. You're the Chief Justice, you're heading the bench in a certain sense, you are the face of the court. And so I can understand the desire to ensure that you preside over these important constitutional cases. But then the flip side is then that there's only one constitution bench, and that of course means that then, you're hearing only one case and these cases go on for a long time. I think the key thing is that, I said two things. One is that I don't think there was anything wrong with the way that, at least in terms of the speed of 377 or of the equal marriage case, which is presently pending decision, and that they need not be at the cost of other important cases. There is enough infrastructure in place to ensure that you can hear all of them expeditiously.
Actually, this reminds me, this is a bit of court gossip, which you may or may not have, but I've always wondered, because that the 2-judge verdict on 377 was overturned so soon, do we know what those judges felt about that? Because that's also unusual, to be sort of snubbed so soon after your verdict.
I imagine that they weren't happy, but, that's the way it is. No, judges can't really defend or, attack their own judgments even after they retire. They're not meant to. They're meant to speak through their judgments. And then we are meant to critique their judgments. That's the way it works. But they're not meant to speak outside their judgments because that is the final word. So when you've given them that power, then it shouldn't be that they also have, then the the liberty of defending it outside of court.
No, speaking of 377, the other thing I was wondering, Gautam, is that, there it recognizes this idea that there can be indirect discrimination, right? That 377, the law itself says nothing about homosexuals, but it effectively targets them. So it's like neutral in a way, but targets them. Could this precedent now be used to claim that other laws, which are sort of neutral on the surface, will disproportionately affect one group, say Muslims or whatever it is?
Yeah, there's nothing that is unusual about that. In fact, in India, that doctrine has been in place since pre-independence times. Under the old 1935 Government of India Act, there was a non-discrimination provision. I think it was 292. I can't remember the exact number of it, were interpreted by the then British court as including indirect discrimination. 1954, there was a case, Bombay Education Society, that said the same thing. And across the world, that's accepted. The exception being the US, which is an exception in many respects in terms of progressive constitutional developments. But everyone accepts that a neutral law, if it's discriminatory in effect, can be struck down on that ground. That is accepted by all sane courts around the world.
Now, to get to some of the issues that you cover in the book, UAPA. First of all, you say the UAPA dramatically flips the regular law of bail on its head. So why don't you explain to our listeners why?
So I'll begin by saying that there is a legal scholar, Abhinav Sekhri, whom I'm sure many of the listeners know, who has explained this in great detail online in many pieces. So if you're interested, that's a great source. To sum up as simply as I can, the basic premise of criminal law is innocent until proven guilty. So you're presumed innocent until the trial is over and you're found guilty by a court. Because trials take time, while your trial is ongoing, you have a right to apply for bail. So until the court pronounces the verdict, you shouldn't be deprived of your liberty. When you are applying for bail and the bail hearing is going on, at that time, the trial is in progress and so on and so forth. So many of the tools that are open to defense counsel in a trial are not open during bail. So for example, in a trial, in our system, that's inspired from the common law, the British common law. The idea is that both sides cross-examine the other's witnesses and all that. And through this exchange of cross-examination, the truth comes out. In a bail hearing, obviously, you can't cross-examine because it's not a trial. The judges are meant to decide a bail case, therefore, on considerations like, is the accused a flight risk? Will the accused tamper with the evidence? Will the accused intimidate witnesses? And then sometimes is the offense so grave, letting them out would, the risk of that would outweigh the demands of personal liberty. What the UAPA does, and this is again drawing from old colonial statutes and the NDPS Act and so on now, is it says that in a bail hearing, if the judge on perusing the evidence is of the view that there is a prima facie case against the accused, then the judge is barred from granting bail. Now, as I said just a while ago, at the stage of bail, the only record is the police record, which is the charge sheet, and all of that. Right? So the only record you have is the police record. Now, the defense can't question that because there's no cross-examination at this stage. And therefore, all that the judge is looking at is the police material. Now, if you say that if the judge believes prima facie the accused has committed the offense, and then they can't grant bail, and the only material is the police material, then that effectively makes granting of bail very, very difficult. So, in that way, the defense is not allowed to question the police case and has to make a case for bail without being able to question the police case. And the law says if the police case is prima facie convincing, you can't grant bail. That's how it flips, the whole structure of criminal law on its head.
And there have been individual cases where the courts did try to protect the individual, but how much of a precedent have they served as subsequently?
So you have judgments where the courts have attempted to find space for personal liberty in the interstices of the UAPA. And there are two techniques that they've used. One is that they've insisted that the police allegations must be specific and particularized. So, for example, if your evidence is that some people exchanged phone calls before a riot, and your conclusion is that they were conspiring to cause riots, there's a huge gap between those two assertions. And the courts have said that it is not for them to fill in that gap. So either the police shows at this stage that evidence that links the two, but the court will not do that job for them. That's one way the court has said that, okay, there's no prima facie case under the UAPA. The second is by reading the provisions of the UAPA narrowly. So, for example, terrorism provision. What does terrorism mean? So you have judgments that have said that, look, terrorism is a specific defined meaning. Not every public order violation is a terrorist act. So therefore, you have to show that on your evidence, which you show at this stage, the legal definition of terrorism has been met if your evidence was correct. And if you combine both these principles, actually a large number of police cases fall away at this stage. They fall apart. So that's been good. But the problem has been that as is the case with Indian courts, for every principle, there's a counter principle that you find in equal number of judgments having upheld. So you have other courts that have filled in these gaps. The most glaring and most shameful example is the Umar Khalid bail denials that have happened at the trial court and the high court level, where this is what happened exactly. There were some phone calls that were exchanged, before a riot, and the police just says, oh, these phone calls are proof that they were conspiring, and the court has said, yes, that conspiracy is there, and effectively what the court says is that a smart conspirator will make sure that the evidence is never expressed. So basically, if you're a stupid conspirator, then you will mess up and evidence will be there. But if evidence is not there, then that shows you're actually smart and therefore you won't get bail. It's just completely absurd. And the problem has been that the Supreme Court on more than one occasion has choked off the progressive line of jurisprudence by saying stuff like, oh, this case will not be taken as precedent. In the Devangna Kalitasha Narwal bail case, so there's a very, very well-reasoned 115-page long analysis doing all this. And the Supreme Court says, we will not take this as precedent. So unfortunately, the Supreme Court's judgments have really stifled the attempts of high courts to craft progressive jurisprudence in the teeth of the UAPA, with some exceptions. So recently, this judgment in Vernon Gonzalez's case was an exception to that.
So, Gautam, why do courts say that this will not be a precedent? I would imagine if you're a judge, you want to be setting precedents.
So, first of all, the Supreme Court and the High Courts they're both constitutional courts. So the Supreme Court is an appellate court in that sense. It can review the High Court's judgment for correctness because they have an appeal system. The Supreme Court has no power to say that a judgment of a High Court cannot be treated as precedent. So that is completely illegal, first of all. Secondly, there is no rationale for it. If the judgment is correct, it's correct on law. It makes no sense. But what happens in court is that, say, if a high court's given a progressive judgment, the state obviously does not like that. The state comes up and says, that this judgment is wrong. The Supreme Court doesn't want to send the people back to jail. At the same time, Supreme Court wants to not confront the state head on. So the compromise is that, okay, these people will be out of jail, but nobody else can benefit from this precedent. And that is completely unprincipled.
Now, let's look at the issue of religion. Over this decade, and you analyze a lot of these judgments from Sabarimala to the Hijab case and, all of the cases that have been going on. How do you see over the decade the court defining the boundaries of religion in sort of our public life?
So I don't think there have been too many cases squarely on that point. I think the Sabarimala case is one example, but that's now pending for a 9-judge bench because it was just unable to enforce it. And the 9-judge bench actually has a number of issues it's dealing with involving the intersection of the rights of women and religion. So the Gulru Gupta case, which is interface between Parsi religion and women's rights. I think the excommunication case is there. FGM. So they're all bunched together in this one 9-judge bench case that will decide all this. I think we're still awaiting that. Of course, Hijab is the notorious one, where the High Court and a split Supreme Court dealt with the issue. So I think overall there's not been much change. There's been this test called the ERP test, Essential Religious Practices, which I think is very flawed. But that basically the court asks that is a particular practice essential to this religion, or in other words, would the religion not be the same without it? And that effectively involves the court in getting into theological questions. So if you look at the Hijab case, for example, both in the High Court and in the Supreme Court, you start analyzing what does the Quran say about the hijab. Is the hijab mandated in the Quran? And that leads to this strange paradox where effectively what you are saying is that the women who want to wear the hijab, they are allowed to wear it only if the religion would not give them a choice in the matter. So if Islam compels the hijab and basically says that you have no choice, then yes, you are allowed to wear it. But if you're exercising your agency, as someone who wants to wear this garment for whatever reason, of assertion of identity or just protecting a beleaguered, space or just, articulating your expression, whatever it is, then you can't do it, right? So this ERP test creates this strange paradox where religious freedom is dependent on religious compulsion. So I think that's the reason why it should not be there. And it's been doubted now in the Sabarimala case and so on, but it's still very entrenched in our jurisprudence. So that's the problem.
But if you wore hijab, not as a matter of religious compulsion, but as a matter of your agency, could that same argument be used by someone saying, it is also my sincere religious belief to wear whatever, a saffron Jai Shri Ram scarf inside the classroom?
Yeah, sure. I mean, I don't think that is a problem. The problem is when expression of identity becomes, in, say, the school space, a form of bullying or suppression or intimidation. And we can all deploy our common sense and understand when that line is crossed. And school authorities have the job of ensuring that the line is not crossed. But if anyone, Muslim or Hindu or Christian or Sikh or Jain, wants to express identity through clothing, through a tikka, through, as in South Africa, a nose ring, or through clothes, we should have that space where that diversity is there in the classroom. So I think that as such, that is not a problem. But of course, you have to look at when that crosses over into the intimidation or bullying space. And that's when you say, okay, as a school, and again, it should not be a state that gets involved. The school should exercise judgment and say that, look, in this context, X or Y is crossing that line from assertion to bullying, and then stop that. That shouldn't be something the constitution or the courts, the state are policing.
Now, the case around reservation. Well, first of all, is there any consensus on whether there is a right to reservation?
That's a complex question. So the Supreme Court has said recently that there is no right to reservation, which is correct in a sort of trivial sense, and I'll explain what that means. So basically, the Articles 14, 15 and 16 of the Constitution constitute what's called the Equality Code. So 14 is equality, 15 is non-discrimination, 16 is opportunity, right? And then 16.4 is reservation, 16.5 and 15.4 and so on. Now, in a case called N.M. Thomas in 1976, if I remember the exact year correctly, the Supreme Court transformed its jurisprudence and said that so far we had held that reservations are an exception to equality, because equality is a formal treatment of treating people the same way. Reservations are an exception to that, which the Constitution specifically guarantees, and therefore they are protected. In N.M. Thomas, Supreme Court said that was wrong. The last 25 years were wrong. The Constitution is committed to a substantive vision of equality, where existing structural or institutional inequality is taken into account in fashioning remedies. So if you are treating people in a formally unequal sense, as in reservations, but the purpose and the effect and the goal is to overcome entrenched barriers of inequality, that actually is in pursuance of equality, a richer, deeper idea of equality. Now, if you look at it that way, then what the Indian Equality Code demands is substantive equality, which means there is an obligation upon the state to take into account existing inequalities and remedy them. Now, that obligation then does not mean there's an obligation to have reservation, because reservation is one policy solution to that inequality. So the state can still choose other forms of remedy, other affirmative action procedures that are not reservations. That choice, the Constitution still leaves the state. Now, that is a nuanced distinction, but what the courts have done is that they have conflated the absence of a right to reservation with the absence of a right to any kind of affirmative action. And so that's where the problem has arisen. So it is true to say that nobody can insist that they have a right to a quota or a right to reservation. What they can insist on is that, look, there is an existing inequality on the basis of caste, and so on. The state has a constitutional obligation to remedy that in a manner of its choosing, but one that does achieve the remedy. So that distinction has been blurred in the court's jurisprudence.
Are there cases is there legal conversation about how do you know when this substantive equality that we are aiming for is achieved in a certain sense? Because that has been the...
Yeah, so from the beginning, so Mark Galanter has this really great book called Competing Equalities, where he discusses the last 60 years and more, pre-independence also, of jurisprudence, where so the term the Constitution uses is socially and economically backward classes. So what does it mean, in terms of economic indicators, cultural indicators with respect to representation in jobs, representation in institutions of education? So you look at, for example, the percentage of population of X, class or caste is actually, say, 20% in X state or whatever. Their representation in jobs is 5%. So clearly something is wrong over there. So all of that has been discussed for many, many years. And of course, it's again ongoing contestation. And the Mandal Commission had 21 criteria to determine what constitutes backwardness. So that is there. So you look at things like income, family, now with EWS, family income, job profiles, representation, political power. So Supreme Court in the Jat reservation case I've discussed in the book looked at political power. So all those you look at, and then it's a value judgment at the end of the day. But you look at issues around representation, income, economic strength, and you come to a judgment on those bases.
But you can come to a judgment about whether or not such a group merits reservation if they're demanding, or if they don't. But is there more push now for what you've been calling, the creamy layer concept, where within a reserved group, certain people, and you hear that touted a lot in general speak, saying like, oh, you have reservations, and look, these people are, economically so well off now, they're riding around BMW, but they're still taking advantage of the quota. And there is a sort of a political push to say this is unfair. Is this something courts are having to tackle?
Oh, so creamy layer was not my coining. That's a very old term that came into being way back in Indra Sawhney's case. I think, if I remember correctly, the first time it was there 30 years ago. That's been around for a long time. No, so I think that there are two things here. One is that the EWS reservation has attempted to shift the conversation from a reservation as a tool of representation to a tool of income deprivation alleviation or poverty alleviation. So the reservations are not a poverty alleviation scheme. So the fact that you have a BMW is irrelevant to the question of reservation. Reservations are meant to guarantee representation of a certain kind and to help in overcoming structural barriers that were imposed on communities by virtue of them being a community. Right? So it wasn't an individual deprivation. It wasn't something that you can fix through an individual process. So that's why, for example, in reservation policy, caste has to be taken into account. And of course, within that caste, some have gained more privileges. But the source of oppression is still caste location. So as you know, you may be rich, but still in parts of the country, if you try and ride a horse, you're going to be subject to serious physical assault. So you could afford the horse for your wedding ceremony, but if you ride the horse, then, you will be subject to violence, and we've seen that. So reservation is meant to tackle that kind of oppression. And of course, with the EWS and some of the judgments in the EWS case, there is an undermining of that, which we see in the debates around the EWS and in those judgments. So we have to see how it goes in the future.
Now, one of the really sort of monumental judgment that came out in this last decade was, of course, the affirmation of the right to privacy, which the Attorney General had claimed did not exist in the Constitution and was sort of resoundingly affirmed. That led to the 377 verdict and all of that. Now that has been affirmed, looking ahead, where do you see the possible impact of that right to privacy playing out?
So I think there were many, many possible impacts, some of which have been realized to an extent and some of which have not. So of course the immediate impact was 377. And when the equal marriage judgment comes out, and in case our side is successful, no doubt the privacy case will play a big role because privacy was framed as a right not just to be left alone, but right to self-determination, decisional autonomy, and so on. So I think in the domain of social progress and the rights of sexual minorities, gender rights, and the recent progressive abortion cases our Chief Justice has decided and so on, you see that judgment playing a big role. So it has played a tangible role in that line of cases. Where it has not yet played a significant role is in actually curtailing police power. So you would imagine that a strong right to privacy would cast certain barriers upon how the police can collect evidence, forcing people to give up their mobile phones, passcodes. So in terms of the extent to which the states, agencies, and the police can encroach on your actual bodily privacy, there has not yet been progress there. So that's the second domain. The third domain, of course, is this whole data protection regime. So now we have a law, and that law falls painfully short of what would be required by a genuine data protection law. And in the privacy case, they set out a bunch of principles that would guide any such law. So data minimization, purpose limitation, and so on. So we'll have to see if and when this law is challenged, whether the privacy case will play a role in the court scrutinizing the ways in which it falls short of genuine protection of the constitutional right to privacy. That's a third domain that it may or may not have an impact in. I think that jury is very much out on the extent to which this judgment, great though it was, will actually play a tangible role in outcomes of cases when it comes to individuals challenging state power.
That's what it seems. It seems to me as a layperson that one is more optimistic when it's a sort of social progressive issue before the court as opposed to an issue involving state power. in terms of which way the court will go. But I don't know, this is just my sort of random guess.
Yeah, and I think that I would not take the social progressiveness for granted either, because actually in its history, our court has not been particularly great on issues around gender and so on. This has changed a lot in recent times, and to be honest, a major driver of this change has been the present Chief Justice, who, is very good on these issues. And if you actually look at it, pretty much all the judgments have been authored by him, or he's been on the bench. So he's been very good on that. But historically, as an institution, the court has not been particularly good on women's rights and so on. And one would hope that his judgments are entrenched enough for that now become a new baseline. But we'll see. But you're right in that even he has been only able to make that progress in this social domain. When it comes to state power or core state power, we've never seen particularly good progress from the court, and neither from the present arrangement of judges has that happened.
And right now, as we end, the big conversation around the country has, of course, been about this whole renaming of India, Bharat, and all of that. And that reminded me of something, when I was listening to that, I was reminded of something in your book where you talk about also this conversation where people looked at certain aspects of the judicial system as relics of Anglo-Saxon jurisprudence. Like in this sort of push for Swadeshi to decolonize our everything, are there parts of our jurisprudence that you think are also might potentially at risk going forward?
I don't think I've seen evidence of that yet. So, for example, if you look at China, right? So there is this whole idea of Asian values and how the human rights discourse is inconsistent with Asian values, which of course, you can challenge that on its own terms, but there is that sense. And of course, I don't mean to reduce a very complex country like China to this one thing, but there is that discourse that percolates through when you hear of it, right? So I haven't yet heard, that there are Indian values that are inconsistent with human rights. Normally the attempt is to synthesize, even from people who are on the side of this particular articulation of decolonization. It's still to say, okay, there is Indian values have their own idea of human rights, but human rights are very much part of Indian values. So I haven't yet seen that. The one domain I've seen that in is this whole idea of rights and duties. So this thing that Indian values are about duties and the West is about rights and we have to focus on duties is one thing I've seen, and I think that that's definitely a risk, because any understanding of state-imposed duties on the individual, history tells us, is a very short road from there to very undesirable consequences. So I think that's definitely a fear that is there looking at the discourse.
Finally, Gautam, I just want to ask you, in this book, as people when they read it will discover, you have not minced words about some former chief justices in your blogs. And in the acknowledgement sections, you've said, over the years, my parents have been concerned that some of the writings on my blog will land me in a pickle. Has it? Have you run into any of these people you've been writing about socially? Has it gotten awkward?
I have on a few occasions, and we have kept it civil. So, yeah, I have not yet gotten into trouble for it. Also, I've appeared before them in court, having written stuff, but so far it's been okay. I think that judges realize that part of the job, involves being criticized, including being criticized for what they would think unfair reasons. And I think that they are trained to internalize their dissatisfaction with that and not let it sort of come out in particular ways, because, And also, I just want to point out there that the criticism that I engage in is very much within the domain of engaging with the law. So it might be harsh, it might be strongly worded, it might be overdone, some people might think, but it's never personal. If you look at the trolling that happens, online, and specifically our present Chief Justice, what I do would seem like milk and biscuits, So I think that once judges see, and I'm sure they do because there's no way they're unaware of it, the kinds of things being said about them, they would see that what I'm saying is extremely civil. So I think that
but for the first time, you are saved by the trolls. The trolls have proven useful.
They've turned me into a moderate centrist, yeah.
Yeah. Gautam Bhatia, thank you so much for joining us today.
Thank you so much.
Gautam Bhatia is a lawyer and constitutional scholar who has been involved in several landmark cases. His new book, based on his blog, Indian Constitutional Law and Philosophy, is Unsealed Covers, a decade of the Constitution, the courts, and the state. Send us your thoughts about this show wherever you get your podcasts from. Find us on Facebook and Twitter and Instagram at Express Podcasts. Thanks as always for listening. This show was produced by Shashank Bhargava and edited and mixed by Suresh Pawar. This is Sandip Roy on Express Audio.